You have to go in with your level of understanding and expertise, right?
Yeah.
And then search. You're the filter by which the searching is done. The average person wouldn't have the same filtering capability as you.
No, and it probably, because you have to read every single document, there isn't anyone who's going to have and take that kind of time. The courts aren't set up to gather that information, but you have to realize that every time the federal government gets sued, it's represented by the U.S. Justice Department, which is basically the largest law firm in the world. And the Justice Department has the capability of putting all that information together. They just haven't done it since 1995.
So did you go to the Freedom of Information Act, or how did you get the rest of your information if the Justice Department didn't have it?
Well, we went to the Justice Department using the Freedom of Information Act to begin with, and when they didn't have the data, we took it on ourselves to find the information. And it has turned out that the problem is much larger than I would have imagined.
Is your concern that there's an ideological, not just agenda, but a perspective that is moving, you call them radical environmental groups, to obstruct the legal system and obstruct good process? What is happening? Is it the obstruction of justice? Is it the obstruction of law? Is it a criminality that is being able to have its way through a loophole? What is it?
I think that some of these environmental groups are simply interested in taking their small agenda and forcing it on the rest of the American public. They know they can't get there through Congress, and so they have figured out a way to just simply crash the system so that they can get there through their agenda. I read an article or an interview with the founder and head of Center for Biological Diversity in December, and he talked about that they were using litigation as psychological warfare. And he was very proud of the fact that they have filed all these petitions, that they simply are stopping projects, and that they are using that as a hammer to force the federal government to do what the environmental group wants, simply because the government can't do the process right, and so they know that they're going to get sued over and over and over unless they capitulate to the environmental group.
Isn't this using the system to crash itself? You know, if this were a civilian issue, someone doing that would be put in jail. Is that correct? Like when people file frivolous suits, isn't there some type of remedy that if someone does that, they're usually put in jail or the judge throws it out? But in this case, it's allowed to go on because why? Because it gets lost in the system?
Well, it's not that it gets lost in the system, but Congress set up, when Congress passed like the Endangered Species Act, I don't think they had any idea that the Endangered Species Act was going to be used to list cave bugs and worms and invertebrates. And so I don't think that Congress had, the foresight, and I doubt if I would have, if I were in the Congress, to have the foresight in 1960 to figure out how things were going to be used in 2009. And so the Congress set up these very tight time frames for the federal government, not having any vision about how things were going to evolve. And so these groups have found these loopholes. They are very valid loopholes. We don't seem to see any will in Congress to close these loopholes. And so these groups, in a perfectly legal manner, are taking advantage of the loopholes and getting paid attorney's fees to do it. Then they've taken advantage of loopholes in the attorney's fees statutes. For example, under the Equal Access to Justice Act, attorney's fees are to be capped at $125 an hour. But the last case in California we reviewed, the attorneys were requesting $650 an hour to write a single brief in front of a court in California. And they justified it because of the cost of living in California is high, even though the attorneys don't live in California, and because they said that what they do is a specialty and how important it was to society, and that's what they requested. And the federal government is now negotiating a solution. So we won't have a court ruling on the fact that $650 an hour is significantly higher than the statutory requirement, because the Justice Department is willing to sit down and negotiate a settlement.
What does that make you feel and think?
Well, it certainly is not a level playing field. I will tell you that in 22 years, I have also requested attorney's fees under these statutes. I have requested the statutory minimum. We have followed the rules, and the federal government forced us to jump through every kind of hoop you can imagine. But in looking at these settlements with environmental groups, quite honestly, they seem a lot more freer with the settlements than they do with industry requests or with landowner requests.
Talk about your law firm, the kind of work you've been doing for all these years. I really think people need to hear the context of your focus, because people may hear it like, oh, they have an agenda, they have an issue with environmental groups, etc. Talk about your areas of practice, the kind of things that you've done and focused on.
Well, I think to do that, you have to understand that I grew up on a cattle ranch in a little tiny town in western Wyoming. I was the fifth generation to live in the same house, work on the same land, and be part of the same ranching operation. And so there really is, for us and for my husband, who is a third generation rancher, a true connection to the land. And in viewing ranchers and in viewing what we do, we have to take care of the land. Because if you don't take care of the environment, you'll put yourself out of business. And it wasn't really until I went to Washington, D.C. and took some other jobs that I figured out that instead of appreciating what landowners and property owners are doing, there's groups out there that are simply against all grazing based on a personal agenda. If you look at the website for Western Watersheds Project, which is an environmental group based out of Idaho, they say it is time to eliminate livestock grazing on the federal lands. They don't look at the acre of land. They don't look at how the rancher is doing it. It's a political agenda. And that's what really got me started in this area. We represent landowners doing a lot of property rights, Fifth Amendment kind of work, taking cases, protecting landowners' rights. We do a lot of work for rural local governments. We try to do a lot of work on zoning issues so that people can use their land correctly and properly.
Have you ever had a lot of cases regarding the eminent domain clause?
Yes, we actually are working on quite a few cases on eminent domain, specifically based on eminent domain granted to utility companies and pipelines and that kind of thing.
Can you explain to the public what it is? Because people have heard of it, but not everybody understands the severity of what it really is and what it means.
Well, based on the latest case by the United States Supreme Court, eminent domain really only deals with how much money is paid to take a piece of property. If you read the Fifth Amendment of the Constitution, the Fifth Amendment says that private property shall not be taken for public use without due process and just compensation. So it doesn't say that you are protected in your property ownership forever, but originally it had three basic requirements: that the government had to show a public purpose, that they had to show due process, which means that they had to give you your day in court, and that they had to pay compensation for the property.
Who determines that compensation? I always wondered about that.
It's usually based on fair market value. But the problem is that the court has really read out the public purpose part of that argument. And so now basically public purpose is whatever the government decides. And there's really no additional review by the court, which I think is a problem. And so it's simply the local government or the state legislature saying, we think this is a public purpose in all cases. We think it's always a public purpose if they want to tear down a housing development and build a shopping mall or a strip mall or whatever. And so the courts have said that's fine. If that's what the local government wants, then we're going to let them have that.
If that's true, what you're saying, and I accept that